Constitutional Commission. 1. Commission on Elections. 2. Commission on Audit. 3. Civil Service Commission. The grant of a constitutional commission's rulemaking power is untouchable by Congress, absent a constitutional amendment or revision. The laws that the Commission interprets and enforces fall within the prerogative of Congress. As an administrative agency, its quasi-legislative power is subject to the same limitations applicable to other administrative bodies. From the case Trade and Investment Development Corporation of the Philippines versus Civil Service Commission, 2013. Constitutional safeguards to ensure independence of commissions. 1. They are constitutionally created, hence may not be abolished by statute. 2. Each commission is vested with powers and functions which cannot be reduced by statute. 3. Expressly defined in the Constitution as independent constitutional bodies. 4. The chairman and members may not be removed except by impeachment. 5. Fixed term of office of 7 years. 6. The chairman and members may not be appointed in an acting capacity. 7. The salaries of the chairman and members may not be decreased during their tenure. 8. The commissions enjoy fiscal autonomy. 9. Each commission may promulgate its own procedural rules, provided they do not diminish, increase, or modify substantive rights, though subject to disapproval by the Supreme Court. 10. The Commission may appoint their own officials and employees in accordance with civil service law. Promotional appointment of Commissioner to Chairman. Section 1, Subsection 2, Article 9d of the Constitution does not prohibit a promotional appointment from Commissioner to Chairman as long as 1. The Commissioner has not served the full term of 7 years. 2. The appointment to any vacancy shall be only for the unexpired portion of the term of the predecessor, from Section 1, Subsection 2, Article 9d. And 3. The promotional appointment must conform to the rotational plan or the staggering of terms in the Commission membership, from the case Funa versus Commission on Appointment, 2012. Jurisprudence on Section 1, Subsection 2, Article 9d. Number 1. The appointment of members of any of the 3 constitutional commissions after the expiration of the uneven terms of office of the first set of commissioners shall always be for a fixed term of 7 years. An appointment for a lesser period is void and unconstitutional. The appointing authority cannot validly shorten the full term of 7 years in case of the expiration of the term, as this will result in the distortion of the rotational system prescribed by the Constitution. 2. Appointments to vacancies resulting from certain causes such as death, resignation, disability, or impeachment shall only be for the unexpired portion of the term of the predecessor. Such appointments cannot be less than the unexpired portion, as it will disrupt the staggering. 3. Members of the Commission who were appointed for a full term of 7 years and who served the entire portion are barred from reappointment to any position in the Commission. The first appointees in the Commission under the Constitution are also covered by the prohibition against reappointment. 4. A commissioner who resigns after serving the Commission for less than 7 years is eligible for an appointment as chairman of the unexpired portion of the term of the departing chairman. Such appointment is not covered by the ban on reappointment, provided that the aggregate period of the length of service will not exceed 7 years, and provided further that the vacancy in the position of chairman resulted from death, resignation, disability, or removal by impeachment. This is not a reappointment, but effectively a new appointment, or is considered a promotion. 5. Any member of the Commission cannot be appointed or designated in a temporary or acting capacity. Still from the case Funa versus Commission on Audit, 2012. Term of office of each Commission member. The terms of the first chairman and commissioners of the Constitutional Commission under the 1987 Constitution must start on a common date. irrespective of variations in the dates of appointments and qualifications of the appointees, in order that the expiration of the first terms of 7, 5, and 3 years should lead to the regular recurrence of the 2-year interval between the expiration of the terms. This common appropriate starting point must be on February 2, 1987, the date of the adoption of the 1987 Constitution. From the case Gaminde versus Commission on Audit, 2000. What does the word term mean? Term is the time during which the officer may claim hold to office as of right, and fixes the interval after which several incumbents shall succeed one another. What does the word tenure mean? Tenure is the term during which the incumbent actually holds the office. The term of office is not affected by the holdover. The tenure may be shorter than the term for reasons within or beyond the power of the incumbent. What are the powers and functions, composition, and qualifications of the members? For Civil Service Commission, Section 3, Article 9b. The Civil Service Commission, as the central personnel agency of the government, shall establish a career service and adopt measures to promote morale, efficiency, integrity, responsiveness, progressiveness, and courtesy in the civil service. It shall strengthen the merit and reward system, integrate all the human resources development programs for all levels and ranks, and institutionalize a management climate conducive to public accountability. It shall submit to the President and the Congress an annual report on its personnel programs. What are the functions of the Civil Service Commissions? A. In the exercise of its power to implement RA 6850, the Civil Service Commission enjoys a wide latitude of discretion and may not be compelled by mandamus, from the case Torregosa versus Civil Service Commission, 1992. B. Under the Administrative Code of 1987, the Civil Service Commission has the power to hear and decide administrative cases instituted before it directly or on appeal, including contested appointments. C. The Commission has original jurisdiction to hear and decide a complaint for cheating by government employees, from the case Cruz versus Civil Service Commission, 2001. D. It is the intent of the Civil Service Law in requiring the establishment of grievance procedure that decisions of lower-level officials in cases involving personal actions be appealed to the agency head, then to the Civil Service Commission, from the case Olanda versus Bugayong, 2003. As the central personnel agency of the government, the Civil Service Commission has broad authority to pass upon all civil service matters. The mandate of the Civil Service Commission should therefore be read as the comprehensive authority to perform all functions necessary to ensure the efficient administration of the entire civil service, including the Central Executive System, Central Executive Service, or CES, from the case Career Executive Service Board versus Civil Service Commission, 2017. What is the scope of civil service? It embraces all branches, subdivisions, instrumentalities, and agencies of the government, including government-owned corporations with original charters. From Section 2, Subsection 1 of Article 9b of the Constitution. The civil service does not include government-owned or controlled corporations which are organized as subsidiaries of government-owned or controlled corporations under the General Corporation Law, from the case National Service Corporation versus NLRC, 1988. What is the composition of the Civil Service Commission? There shall be a chairman and 2 commissioners. Qualifications: natural-born citizens of the Philippines. B. At the time of their appointment, at least 35 years of age. C. With proven capacity for public administration. And D. must not have been candidates for any elective position in the election immediately preceding their appointment. What is the term of office? 7 years, except those first appointed. What are the classes of service? From the case Civil Service Commission versus Sohor, 2008. A. Career service. Career service is characterized by entrance. A. Based on merit and fitness to be determined as far as practicable by competitive examinations, or B. Based on highly technical qualifications with opportunities for advancement to higher career positions or security of tenure. Number 1. Open career positions, where prior qualifications and an appropriate examination is required. 2. Closed career positions, exempli gratia, scientific, or highly technical in nature. 3. Career executive service, exempli gratia, undersecretaries, or bureau directors. 4. Career officers, other than those belonging to the career executive service or appointed by the President, exempli gratia those in the foreign services. 5. Positions in the AFP, although governed by a different merit system. 6. Personnel of government-owned or controlled corporations with original charters. 7. Permanent laborers, whether skilled or semi-skilled or unskilled. And B. Non-career service. What is non-career service? It is characterized by entrance on basis other than those of the usual test utilized for a career service, tenure limited to a period specified by law, or which is coterminous with that of the appointing authority, or subject to his pleasure, or which is limited to the duration. 1. Elective officials under personal and confidential staff. 2. Department heads and officials of the cabinet rank who hold office at the pleasure of the President and their personal and confidential staff. 3. Chairmen and members of the commissions and bureaus with fixed terms. 4. Contractual personnels. 5. Emergency and seasonal personnel. Note: except as otherwise provided by the Constitution or by law, the Civil Service Commission shall have the final authority to pass upon the removal, separation, and suspension of all employees and officers in the civil service, and upon all matters relating to the conduct, discipline, and efficiency of such officers and employees. Appointment in the civil service. The role of the Civil Service Commission in appointing process is limited to the determination of qualifications of the candidates for appointments and plays no role in the choice of the person to be appointed. General rule. Made only according to the merit and fitness to be determined as far as practicable by competitive exams. Exceptions. 1. Policy determining. 2. Primarily confidential. And 3. Highly technical. Policy determining. Where the officer lays down principal or fundamental guidelines or rules, or formulates a method of action for government or any of its subdivisions, example, department head. 2. Primarily confidential, denoting not only the confidence and the aptitude of the appointment for the duties of the office, but primarily close intimacy, which ensures freedom of intercourse without embarrassment or freedom for misgivings or betrayals on confidential matters of state. From the case de Los Santos versus Malyari to 1950, or one declared to be so by the President of the Philippines upon the recommendation of the Civil Service, subject to the judicial review. From the case Salazar versus Mathay, 1976. 3. Highly technical. Requires possession of technical skill or training in supreme degree. From the case de Los Santos versus Malyari, 1950. Disqualification. From Article 9b. 1. No candidate who has lost in any election shall, within 1 year after such election, be appointed to any office in the government or any government-owned or controlled corporation or any of its subsidiaries. 2. No elective official shall be eligible for appointment or designation in any capacity to any public office or position during his tenure. 3. Unless otherwise allowed by law or by the primary functions of his position, no appointive official shall hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. 4. No officer or employee in the civil service shall engage directly or indirectly in any electioneering or partisan political activity. Removal or suspension only for cause. No officer or employee of the civil service shall be removed or suspended except for cause provided by law.